we always classify the law between the first one is written and unwritten laws. Written and unwritten law. The second one is national and international law. The third one is national, international law. Then we have, sorry, there I have gotten the slides finally. So national, international law. The third classification is between civil and criminal law. The fourth is between civil and criminal. Then we have substantive and procedural law. Thirdly, we come finally to common, not common and civil law, civil, criminal, substantive, and procedural. Those are the main classifications of law we're going to learn about this afternoon and finish on the first topic. So give me a quick minute. My slides are opening, so I'll be able to share my screen in the next few minutes. There we go. Sorry, yes, I'm not sure. Okay, can you hear me? Can share my screen now. One stop from current slide. So nature, purpose, and classification of law, that is the topic we were covering since last week. It's already on your, all these notes, you'll find them, on the notes on the slides, you'll find them on your e-learning. So for today, we're going to pick up on classification of law, which is a short bit. And I've told you these are the various ways through which you can classify the law. The law may be classified as written and written law, municipal, national, public and private, procedural, substantive and procedural law, criminal and civil law. So let's start off with written law. What is so special about written law? So we can talk of it as written or codified law. It is written or codified law. It is codified law, and then unwritten law. These are rules that are not contained in a formal document. It looks very simplistic. This distinction between written and unwritten law. However, it's not at the complex, but the key distinction to capture here when you're trying to classify between written and unwritten law is that written law is contained in a formal code. It is very formal, and then it is complete. It is a complete set of legal rules on a particular subject or on a theme, and that is written law for you. When you cross over to unwritten law, on the other hand, is not contained in a formal document, and it doesn't mean it is not where in writing. It is law that is scattered in various sources. It can be anywhere in writing, but it is scattered in various sources. So that's where the difference comes in between all these laws, written and unwritten law. So a good example of written sources of law are statutes. We're going to learn about statutes. Statutes are laws that have been made by Parliament. When Parliament makes statutes, the statute I will download one and show you when I'll be discussing sources of law in Kenya. When we'll be looking at the Judicature Act, and you can see the format of a statute. You can find a PDF copy and download it online from the website of Kenya Law, or you can go to the Kenya printers and the government printers and buy a hard copy of a statute. So that is written law for you. It can be divided into. We have the Constitution. For starters, that's another example. We have statutes. When we come to unwritten sources, a common example of unwritten sources are customary laws. Okay, so customary laws is what is a common example for this. We have many communities in Kenya, and these communities all have different customs. And all their customs are not contained in the book. There's no day you'll come to Nyanza, for example, and find a whole book or a whole statute code containing the customs of the Luo. No, these customs are passed down from one generation to the other. And they apply to a certain extent, especially when determining civil matters of marriage and succession. You'll find that people fall back on their customary practices. You might find customs written in certain texts. I hope you can hear me. You might find customs written in certain texts. I've just seen a message. Let me read it very quickly. Yeah. You can find customs written under certain texts. I've seen your question, I will address it, but it does not mean that they are written. They have to be written in a formal document. If they're written in a book is not a formal statutory document. So even though they're written in a book, they still will classify them under unwritten sources because of the lack of a legal instrument in which they are codified. But for written, they are contained in a formal legal instrument known as a statute or known as a constitution. Then one of your colleagues has asked a question here. Let me address it. Yeah, was it? So the question is as follows: are the Ten Commandments classified under written or unwritten law? And it's a good question, and I like the fact that he has asked this question or she has asked this question. Mm, the Ten Commandments, are they even sources of law to start with in Kenya? Does the government of Kenya recognize the Ten Commandments as a source of law in Kenya? The straight answer to that is no. Okay, we have a positivist approach to our laws. We only define law as rules that have been made by man, not religious, not God-given rules. So those are the rules that the court will use to interpret any disputes that come before it. So the Ten Commandments even are not recognized as formal sources of law. Yes, they are binding to us in our daily living as when we ascribe to a certain faith, but the bottom line is when someone breaks a commandment, you'll not arrest them unless it has been criminalized. Okay, so those are the issues we're dealing with here. Next, we have municipal/national law versus international law. When we come to municipal national law, this refers to rules of law that are applicable within a particular country or state. Another word for it is state law. Mm, how many countries are there in the world? This is a question to the whole class. How many countries are there in the world? Okay. Or in the African continent. Let me see. I think there's someone who has texted a response here. Okay. How many countries are there? 195 countries and counting, yeah? And in Africa, we have, I think, 54 states. So each country has its own government, its own parliament, its own ways of making laws. 197, 55 in Africa, 197 in the whole world, I agree. So each of these 197 countries, depending on if you recognize certain states as countries, there's always been that disputation. All of them have their own national borders, they have their own parliament, they have their own judicial system. So national laws are laws that apply within a particular country, within a particular state. It refers to rules of law that are applicable within a particular country or state, also state law. It regulates the relationship between citizens inter se or amongst themselves. Give me a quick minute. Yes, I'm here. Oh, give me a quick minute. I respond to a call.
the start of round number 4. This isn't weekend mini golf bragging rights. This is $250,000 on the line now. Valerie Sestak, 20 years old and dreaming of success. Our youngest champion. And goes in front. What in the world? What? Oh, and it rolls. I've never.
There's a pen, and a ruler, and a spirit. Yeah, that is really good. Sorry, I'm going to have to say a minute. That's just blown my mind. Let's see how good it is. How does it write? It's beautiful. What's this on the end? But it's going to be something good, like a laser pointer or something. It's a screw.
All right, so municipal national law, it refers to rules that are applicable within a particular country or state. I've already asked you how many countries are there in the world. You have told me around 197, 195 thereabouts. And I was trying to explain to you each country has its own boundaries, judicial system, the way, even language. There's a lot of differences even in the law of the world as well. So that law that applies within the nation is what we call national law. Okay. So all these laws that apply within Kenya, they are our own national laws. But you cannot take Kenya's national laws and apply them in Uganda. Museveni will not allow you to do that because even Museveni, he is the head of state for Uganda and they have their own system of laws and how their laws are made. And we usually contradict this. We usually distinguish this. We distinguish this with international law. So international law is a body of rules that generally regulates the relations between countries or states and other international persons. International law is a body of rules that regulates the relations between countries or states and other international persons. It originates from international treaties or conventions, general principles, and customary practices of states. So this is where now it gets a bit more interesting. We have a law that applies between two or more states. And this law that applies between two or more states, we call it international. We call it international law because it applies between two or more states. And this kind of laws, how do we form them? Does Uganda, Kenya, Tanzania come together and make a law that will regulate their relations amongst themselves as countries? And this is where you find that you form them through what we call international treaties. Some of you have already heard of treaties before. And I want to just ask members of the class to help me define what is a treaty or a convention. Can anyone help us? Share with us the knowledge they have. What is a treaty or a convention? A treaty, class? Okay, text. Sorry. I think you prefer text than speaking. Okay. In an agreement, excuse me. It is an agreement between two or more parties with some conditions, with some conditions to be met. Formal agreement between countries, agreement between two states, formal and binding agreement between two states. An agreement between two or more states with conditions. So you have an idea that a treaty is an agreement because at the international level, we have two states that have equal standing. So one cannot dictate conditions to the other. Instead, the states will come together and enter into a legally binding agreement in the form of a treaty on how they're going to regulate their affairs. So it originates from international treaties or conventions, general principles, and customary practices of international law. So international law has two main branches. it has two main branches. We have public international law, and then we have private international law. Huh. Who punishes breakers of such laws? So, whenever a country does not conform to a treaty obligation and there's a dispute, this dispute usually goes to an international court, not the ICJ. It goes to an international court known as the International Court of Justice. The International Court of Justice is one of the organs. It is one of the organs of the United Nations. One of the organs of the United Nations. So it's one of the organs of the United Nations, and its work exclusively is to settle peacefully disputes between states. For example, just give me a quick minute. So, public international law, private international law, we find that public international law regulates the relations between various nations. It is derived from the customs, the conventions. So the difference in public and in private is that this is international law that regulates the relations between states. Private international law is law that regulates the relationship between private states of different, private citizens of different states. So that is the main difference. One regulates the relations. I'm sorry, I'm just trying to look at the chart as well. What if a country is not a member of the UN? Good question. Who knows of a country that is not a member of the United Nations? A country that is not a member of the United Nations? A country that is not a member of the United Nations.
Hi, ma'am.
Hi.
One program about date nilikuwa nimeenda kususu na dada akanifukuza kwa kitanda. Ndio tena atanifukuza.
Sorry. So the Vatican, Palestine, Turkey was also on its way out. Vatican, Holy See, Palestine, Vatican. Okay, Vatican is not is it really? Okay, who can help us explain the international status of Vatican? What is the international personality of Vatican? Even though Vatican is not a member of the even though Vatican is not a member of the United Nations, it has a seat. It has a special seat that it has been. There's a special status it has been accorded. I just need to refer to my textbook of international law. But there's a special seat it has been accorded, and hence it can take part. It can take part in some of the discussions that are going on. What it cannot do is to vote, because Vatican is already in Italy and Italy has a vote. But even the relationship between Italy and Vatican is also different. We also, but the most notorious one that I expected you to tell me about is North Korea. North Korea is just that one country that is so rebellious and has refused to join the UN so many times. So how does international law act when it comes to such countries, although they are very few and you can count them? What happens is they will not be bound, yes. However, now, if people cannot settle their dispute peacefully, that's why they have a military. That's why we have an army, so that where our interest as Kenyans is threatened by external factors, the army is there to give us that protection. So that's why countries go to conflict when they're not able to amicably settle their disputes. The UN was formed to maintain international peace and security, to give the countries a fora through which they can be able to sort out their disputes. So that's the thing about the United Nations. Okay. Moving forward with the sources, I hope I'm still sharing my screen with all of you. Am I? I have now stopped the sharing. Let me come back to Zoom. So I hope you are able to you'll be able to distinguish between public international law and private international law. Public international law regulates states, two states or more. Okay, it regulates the relationship between states. They can be two, they can be more, but that is the role of public international law. Private international law, on the other hand, is it determines the national law that is to be applied by the court between foreign citizens. If Chinese, the way there are so many here in Kenya, if a Chinese citizen is in Kenya and that Chinese citizen, even if they're not in Kenya, they're in China and there's a Kenyan citizen and they're doing business together, and one of them does not respect the contract or something happens in their relationship, their business relationship, they need a court to solve that issue, then that comes the area of private international law, where it tries to determine how such conflicts can be solved. The same way, under international law, we have a distinction between public international law and private international law. Just give me. So public law, it consists of those fields of branches of law. The same way international law has two branches of law, the public and private. National law also can be further distinguished into public and private law. So public law, it consists of those fields or branches of law in which the state has a direct interest as a sovereign. It is concerned with the constitution and functions of the various organizations of government, including local authority, their relations with each other, and the citizenry. So public law includes criminal law, constitutional law, and administrative law. Sorry, I've moved so fast there. Let me give you time to absorb that a little bit. Okay. Okay. So, right. I know you have just started the class. It's hardly 30 minutes, but please, I'll give you a 10 minutes break because there's something I need to sort out from my end. I told you I'm having a few technical challenges on my end. So please take a 10 minutes break, in initial 10 minutes break, and then we resume from public international law. Please let me handle something on my end that is a bit urgent. Is it okay? 10 minutes, please. We start at 3. Let's start at 3:20. We will make up for that time that we lose. Thank you so much for your understanding. I'll mute myself and I'll be back in 10. Sorry. What are they? So let me share. Let's continue, please. All right. So I was just trying to explain to the class that when it comes to national law, national and public law, we find that even within the nation, we have two distinctions. We have public law and we have private law. So for public law, here it is not a matter of state relationship with each other, because we said that in public international law, it regulates the relationship between two states. But in public law, and this is public national law, not public international law, public national law is about regulating the relationship between government. It's between the relationship between government, one, and number two, yes. Oh, sorry. A minute. So we have said that public international law is about the functions of government and how government is performing these functions. The functions of government and how government is performing this function. It regulates the relationship between private citizens and their government. So
Hello?
Yes, please. Hello.
Hello, this is Grace University of Nairobi Graduate School.
Yes.
Why haven't you said your letter is almost expiring?
Oh yes, my letter. Can I come? Do you have? I applied for an extension. Do you have that? Did I receive the extension?
Yeah, but now there's no we can extend your letter without a registration number.
Okay. Can you please give me? Can I come to the graduate school?
We are not students.
So I am in a meeting.
So,
can I call you? What time can I call you? I'm in a class.
Tomorrow at 11.
Please let me call you tomorrow at 11. We discuss this because I'm in a class and the students are waiting on the other side.
Okay.
I'll call you tomorrow at 11. Thank you so much.
Yeah.
Okay, bye. Oh, so it consists of those fields or branches of law in which the state has a direct interest as a sovereign. It is concerned with the constitutions and functions of the various organizations of government, including local authorities, their relations with each other, and their citizenry. So that comes to public law. It is about the state and the private citizen. A good example is criminal law. Criminal law is a classic example of public law because the person involved is the government and the private citizen. So the law between the government and the private citizen, because the law is about regulating relations. So that law that regulates relations between that state on one side and the private citizen on the other is what we call public law. So the criminal law will tell the state when I can be arrested for having committed a crime or on suspicion of having committed a crime. Criminal law tells the government what rights I have as a as an arrested person. Any branch I have, it regulates my relationship between my state and the members of and the private law. So it consists of those fields or branches of law in which the state has a direct interest as a sovereign. It is concerned with the constitution and functions of the various organizations of government, including local authority, and their relations with each other and their citizenry. Okay, so next we come to examples. I've already given you the example of criminal law. I've already given you the example of criminal law. I've given you the example of constitutional law, and I've given you the example of administrative law. Public law enables the government to assert state sovereignty. So private law. Private law, it consists of those branches of law in which the state It consists of those branches of law in which the state has no direct interest. So a private law is the law that governs the relationship between the private citizen and the private citizen. The private citizen and the private citizen. So that is why we call it private. It consists of those branches of law in which the state has no direct interest as a sovereign. It is basically the relationship between a private citizen and a private citizen, not a private citizen and the state. It is about so it is concerned with the legal relationship between persons in ordinary transaction, the law of contract, the law of property, the law of succession, the law of marriage, and the law of tort. Those are examples. So substantive law, on the other hand, we have already distinguished between private and public and private law. The second one is substantive law and procedural law. So what do we mean by substantive law? Substantive law consists of rules. We have so many rules that have been enacted by Parliament in the form and style of law. Okay? I mentioned at the beginning of the class that one of the main sources of law is a statute. A statute is a source of law. Why is a statute a source of law? Because it regulates the relationship between statutes are made by Parliament to regulate citizens within a nation of that Parliament. So all these rules that we have, we call them, as long as they just consist of rules that dictate duties, that dictate rights, that create obligation, then that is what will happen. That it consists of the rules themselves as opposed to the procedure on how to apply them. It defines the rights and duties of the parties and prescribes the remedies applicable. Substantive law defines offences and prescribes punishment. For example, the law of torts, the law of succession, and the law of contract. Okay. When it comes to procedure, we have said substantive law is the law that dictates the duties. Okay? It is a law that dictates the duties of the citizens. It creates rights, it creates obligations. When it comes to criminal law, it is that law that defines offenses. It is that law that prescribes punishment for offenses. Examples of these laws, we have the law of torts, we have the law of succession. This law of succession is the one that guides us when it comes to inheritance, matters inheritance, and how property is inherited on the name when one is deceased. So the law of contract, it tells us the rules about the relationship between the parties. So all this falls under substantive law. And you always have to distinguish between substantive and procedural law. The other word we use in terming procedural law is adjectival law. Okay? I hope I'm still connected to the internet. So this is adjectival law. It consists of the steps or the guiding principles or rules of practice to be complied with in the administration of justice. So steps, guiding principles, rules of practice to be complied with in the administration of justice or the application of substantive law. For example, the Civil Procedure Code and then the Criminal Procedure Code. So it just gives us the procedure. And it is this procedural law is now where that draws the difference between a lay person and an advocate. Whenever you want to understand the procedure of doing something, that is when you find yourself consulting with an advocate. You can also consult with an advocate when you don't understand what the rights and duties in a situation are. So that can also help you consult with to understand what your rights are, to understand what your duties under a taxation law, for instance, is. But procedural law is now the law that gives us the step of enforcing the substantive law. For example, if you want to file a lawsuit today in Kenya, it is procedural law that will give you the procedure of what to follow until you file your lawsuit, until your case is heard in court, determined, and a final judgment given. Criminal law, on the other hand, for example, criminal procedure, it is a procedure that tells us what happens step by step when one person is arrested. For example, when I'm arrested by the police, what next? It is criminal procedure that stipulates that. They should take me to the police station and hold me there. What if I have a bail to pay them? They can release me on police bail as long as I go to court. When I go to court, what is the procedure to be followed? All those steps are outlined under procedural law. It consists of the steps or guiding principle or rules of practice to be complied with the administration of justice. The Civil Procedure Code, the Criminal Procedure Code. And then finally, we have to distinguish between criminal law and civil law. The bulk of all the laws we have in Kenya and in many countries will always have to be distinguished between these two. Even today, if you do what? If you go to court, if you do what now? Which example do I want to give? Yeah, sorry. So, criminal law. Criminal law is an interesting area of the law that you need to understand clearly. I hope we are together. I'm very sorry for the many disruption that has been during our class. Everyone has those days. You have just a day where there are many hurdles that you need to cross, and sometimes it's easier to just give up and say, you know what, we can have our meeting next week. However, we always have to try. We have to soldier on and try to salvage to salvage the day and the time, because time is so precious. When you miss 3 hours with your student, it is just it takes you back. It takes you back. Now, like I'm teaching you classes, IT and business law and computing law. So you find that the one class is ahead of the other class is behind. You're struggling to finish content, and there's a lot of content. So I want to apologize for all those disruptions. They might not stop, they might keep coming because this is just one of those days. However, bear with me, and let's soldier on together. Okay? So, what I was discussing criminal law, and I was telling you that this is a law that all the laws of a country, yeah, that's where I was. All the laws of a country can be divided into either criminal or procedural, criminal or civil, and within civil you can also find further divisions. If you go to Milimani Law Court today, and you want for your case to be heard in the court will decide your case. The court will decide your case based on the court will be sitting either as a criminal court or as a civil court. So you find most courts will always sit. They're either sitting as a criminal court or they're sitting as a civil court. So that is the other issue that we have. Okay.
Niandikie.
Tafuta kitabu yako uleta nikuandikie kitu uandike. Leta textbook yako. Leta textbook yako.
Sababu gani? Mimi sina kubwa. Nimalize hiyo picha.
All right. So we are having. I was explaining to you how the courts work. That the court can sit either as a criminal court or as a civil court. That is why it is very important for any student learning law, even at a basic level, to understand the difference between criminal procedure, civil procedure, criminal law, and civil law. So that when you're arrested or when you're dealing with the court system, you want to understand: am I being arrested for a crime? You have seen it in the movies, yeah? Which crime have I committed? Because you want to know which law exactly have you broken. When you're sued in court, what you worry about is how will I deal with this civil suit? Because for that it is a lawsuit. So, criminal law is a substantive law. As a substantive law is a body that prohibits certain kinds of conduct and imposes sanctions for unlawful behavior. It prohibits certain conducts. Can we hear from the class? Can the class give us examples of some of these conducts that are prohibited under criminal law? Examples of conducts that are prohibited under criminal law? Rape, murder. So you're in fact to give me examples of crimes, yeah? You're naming crimes. Even crimes have names. So you are naming crimes, and these crimes are broadly defined. Yeah? So those are examples of crimes or acts that have been labeled criminal activities. You can imagine how people usually use that word, that you're engaging in criminal activities. So yeah, you have an idea. I've seen your contribution in the chat. A body of law that prohibits certain kinds of conduct, imposes sanctions for unlawful behavior. That is criminal law. It defines the conduct that amounts to a criminal offense. So, for example, theft. Theft has to be defined. when exactly do we say that an individual has stolen? So if you look at the criminal code, the penal code of Kenya, the statute that creates criminal offenses, it has defined all these crimes. It has defined theft. And we always, as lawyers, have what we call essential ingredients, that whenever someone commits a crime, for you to be sure they have really committed that crime, you have to interrogate and see, are the essential ingredients of this offense, have the essential ingredients been met in those actions? So that is the work of criminal law. It defines, it names the crime rape, and it goes ahead and defines what amounts to rape. It defines the conduct that amounts to the criminal offense of rape, and then after that, it says the punishment that one is supposed to face if they have been convicted of such a crime. Another terminology that is used for criminal law is that it is the law of crimes. The other terminology is that it is the law of crimes. Okay, so the other is, this is the law of crimes. That's the other terminology. A crime is an act or omission committed or omitted in violation of public law. A crime is an act or omission committed or omitted in violation of a public law or a statutory law. Crimes are created by Parliament, by the way. It is the work of Parliament to make laws. It is the work of Parliament to pass all sorts of laws, even including criminal law. Examples of statutes that create criminal offences in Kenya include the following. So in general, why do we have certain conducts? Why do you think we have certain, and I don't want you to write in the chat, I want you to unmute yourself and speak to me, or else I will also mute myself and teach you through the chat. Do you know how teaching online is a very lonely endeavor? So please unmute yourself and give me some of the reasons why certain conducts have been prescribed as crimes. Why do we have certain conducts prescribed as crimes, please? What are some of the reasons? Okay, or why are certain conducts criminalized, certain actions criminalized, or certain omissions criminalized? Why? What is the reason for creating this area of law we call criminal law?
Hello?
Yes, please.
Yeah, I guess it's because they do harm to other people. So as long as an act does harm, then it is legalized.
Mm-hmm. Indeed. Thank you for that contribution. Harm. Can you imagine? Yeah. When someone, there's certain criminal conduct. Why do human beings commit crimes? Why do they harm others? Moses Karanja, nimesema you have to unmute yourself. There is no speaking to me on the chat anymore. I want to hear your voices. It's very lonely teaching online and only reading chat messages. I want to hear the voices of my students. Please admit yourself, Moses, and explain that very reason you've given on the chat.
Can you hear me? Can you hear me?
Moses?
Yeah,
Mhm.
Can you hear me? Can you hear me? Hello?
Go ahead.
Sorry. Can you hear me?
Yes, I can hear you.
Okay, I was saying that if a certain act is performed on a person and leaves the person in a negative state or in a worse state than he or she was in before, the conduct of the act should be classified as a crime. For example, let's say you're driving and you smash another person's vehicle, the person will now have to carry out repairs, of which, if you had not crashed into the vehicle, the person's day would have continued as normal, therefore leaving that person in a negative state than the found the person.
Nigga cabbage.
Yes. Criminal activities causes harm. I can thank you, Moses. At least you've attempted, even though your mic has an issue. I have heard your voice, and I'm very grateful for that. So I will just read your points still. I agree with you. Criminal acts have to be penalized. They have to be. They cause a lot of harm in the society. They cause people to suffer injuries. They cause loss of life. They cause loss of property. So those are some of the reasons why we have criminal laws, and Moses and the previous contributors are correct. So let's continue from there and see some of the reasons we have here in the slides. Okay. Current slide. So criminal law. In general, the prohibitions contained in criminal offences are concerned with protecting the public at large and maintaining the accepted values of society. These values of societies include the preservation of morality. So some crimes are geared towards preserving the morality of a society. These include crimes against obscenity, prostitution offences, protection of the person. We want to protect a human being, their person, their physical body, and such crimes that are geared towards this end are, as example, murder, assault, protection of property, and some of the crimes that are geared towards this end, where it is about protection of property, are theft and fraud offences, preservation of the public peace, incitement to riot, and causing a disturbance offences, and finally, preservation of the state, example, treason offences. So that's where we are at. In Kenya, we have a number of laws that create crimes. The main one is known as the Penal Code, Chapter 63. It is an act of parliament that has been there for the longest time. This is where we have the crime of murder, robbery with violence, and the rest. Number 2, we have the Anti-Corruption and Economic Crimes Act. Also, this one creates a number of offences related with corruption. The Sexual Offences Act, this is where you get all those heinous sexual offences. Act defined all those heinous sexual crimes defined. Prevention of Terrorism Act is also a statute that has been passed by Parliament to create specifically offences with regard to terrorism. Narcotic Drugs and Psychotropic Substances Act. Then the Traffic Offences Act and Regulation. So these are the acts that are examples of them. And most of you, anyone who has ever been arrested of a criminal offense, most of us here, even me, have been arrested for a traffic offense. Waweru. Waweru Madenga is asking a very interesting question. Waweru, please ask your question. Unmute yourself and ask your question. I want to hear your voice.
Hello, hi.
Yeah.
Yeah, so you actually asked this question and you wanted us to answer, but I don't know. You kind of veered off it. So it's, why do human beings inflict harm on other human beings? Because that's probably the reason why there are laws. It's because human beings inflict harm on other human beings. So there need to be laws to protect those other human beings. So why is it, what are these motives that would make you want to inflict harm? And especially for, if you look at for narcotics, you would say that a drug user is committing a crime, but he's doing it to himself. So how is that a crime? But yeah, that's what I wanted to get at. But yes, on the issue of drug abuse.
Yeah, thank you so much, Waweru. I appreciate that. In fact, I'm just soaking that your thoughts in there and just pausing. You know, sometimes when you hear a very good contribution, you pause first of all to really, like severe it. Not severe. There's a word there I want to use. but it's not yeah, that's the thing. That's the thing. And that's what criminologists learn. Personally, I am not a trained criminologist, but there are people who do, not law, but they go and learn about, they do a bachelor degree in criminology. And criminology is where they try to understand the human psyche, and understand psychic things. Why do they behave in such and certain behavior? You remember those descriptions? Oh no, you are not in my LLB class. In my LLB class, our criminal law, one of the topics we covered under our criminal law was to look at human beings. We could classify them into mesophobes, endoforms, the way they look different. And they're just people who, by their physical appearance, they have an inclination of committing crimes. That's unfair. Now I feel I wish I could challenge my teacher with that information, because I don't think you can just judge because someone is built and they have a serious face and they have a certain frame of body, then they are most likely to be criminals. No. So then those are the matters interrogated by criminologists: why human beings commit crime and the rest, and harm others, and cause death and things like that. And so we'll not pursue that further in our class. But if you're interested, you can read on it. But thank you for bringing it up. Okay, moving on to slides. Sorry, I'm so used to teaching without slides. I think I will. Traffic offences. I was asking who has ever been arrested for a criminal activity. I've been arrested. I was arrested. I've been arrested not twice, just once or twice, for not tying the seat belt. For not tying the seat belt. Mutuma, please just unmute yourself and ask a question. You don't have to type that you have a question. Just unmute yourself and ask it. Yes,
you defined a crime as an act or omission in violation of the public law. What's an example of an omission that is a crime?
We call it we have they're not many. Hey, you're very keen, eh? Hey, you're a keen student. That's a tough question you've asked me right there. There are not many crimes that consist of an omission in the penal code itself. However, there's one where we call negligence leading to loss of life. Do you know there are times when someone has omitted to do something that was so important to be done, and because of their omission, someone lost their life. So that's part of there's a crime associated with that, like negligent. Through one's negligent actions, they enabled for a crime to happen. Things like collusion, you colluded by your inaction. Yani the action, the negligence is just criminal. In fact, to be more clear,
Excuse me, madam.
please, you are excused. If you have a question, just ask.
Yeah, on that question of crime by omission, would you classify failure to pay taxes as one?
Tax evasion as a crime of omission? No, not tax evasion. Because tax evasion is because you omitted to pay taxes. Now you have
Yeah, it's like you're being punished. Something you haven't done.
No. You've not done something that you needed to have done, yeah?
Yeah.
By the way, that sort of makes sense. I've not ever looked at those tax evasion crimes as that, as a crime, as an omission where, that makes sense. Because you've omitted your public duty to pay taxes. So even the way the crime is defined, it will be defined in the sense that you had an obligation to pay taxes and you omitted to pay those taxes, or you paid less taxes. Yeah. I'm trying to look for a counter argument, but I can't come up with one. I think you're right. I agree. So the next thing I need is crimes of omission example. They're not many, so that's why I'm googling them. Crimes of omission. I agree with the tax evasion. Yeah. This is what I wanted to tell you, the omission by murder by omission. We call it criminal negligence. Yeah, that was the term I was looking for. So criminal negligence, although the example we have been given is also a very on-point example about tax evasion. So that is also a good example. I accept it. Thank you so much for that example. Let's move forward, having answered that question. Civil law now. We have crossed over to civil law. What then is civil law? Civil law is usually just defined as anything else that is not criminal. Anything else that does not fall under criminal law will automatically fall under civil law. So civil law deals with disputes between private parties or negligent acts that cause harm to others. Example. So any non-criminal action will fall under civil law. So can you imagine how wide civil law is? You take the body of law, you subtract criminal law, what you're left with is civil law. So civil law is very wide. If individuals or companies disagree over the terms of an agreement, or who owns land or buildings, or whether a person was wrongfully dismissed from the employment, they may file a lawsuit asking the court to decide who is right. So that's an example. These are just examples. The failure to exercise the degree of caution that an ordinary prudent person will take in any situation may result in a negligence claim. Depending on the circumstances, a person may be held responsible for any damage or injury that occurs as a result of their negligence. That's another example. Family law cases involving divorce, parental responsibility for children, spousal support, child support, division of property between spouses, family feuds, civil. Challenges to decisions of administrative tribunal, allegation of medical malpractice, and application for distribution of estates of deceased. All those are civil. So civil is anything else that is not criminal will fall under a civil law. So the party who brings the legal action is known as the plaintiff or the applicant, while the party being sued is the defendant or the respondent. The court may dismiss a case if it is found to have merit. The court may order the losing party to take corrective action, although the usual outcome is an order to pay damages. When a person's civil or private rights are violated, he is said to have a course of action. So that's the thing. The party, so this is about lawsuit. It is not about a criminal case. In civil matters, no one is arrested. When people are divorcing, you don't arrest the divorcee and start asking them, why are you divorcing? Okay? Because it is their right to divorce. Sorry. So The party who brings the legal action is known as the plaintiff or the applicant. The party who brings the legal action is known as the plaintiff or the applicant. A classic example of a civil lawsuit is where you have loaned someone money, you have given them a loan of, let's say, 50,000 Kenya shillings or even 5,000. Then they have refused to pay you. You have followed them, you have written letters to them, so you have decided to file a lawsuit so that the court can help you recover your money. So that is a classic case of a civil lawsuit. So you, as the person who has filed a lawsuit, we call you plaintiff or applicant. So the party who brings the legal action, the bereaved party, is known as the plaintiff or the applicant, while the party being sued is the defendant or the respondent. The party being sued is the defendant or the respondent. The courts may dismiss a case, or if it is found to have merit, the courts may order the losing party to take corrective action, although the usual outcome is an order to pay damages. So dismissal of a case is one of those actions the court can take if it's found that the case is frivolous and without any merit. However, if the court really found that indeed this person was given a loan, there's even an M-Pesa message. He has been sent for so many texts to pay back this loan and they have refused. So the court can give an order for the losing party. They can give an order for the party who is sued, who usually call the defendant, to pay you the sum of money that they owe you. When a person's civil or private rights are violated, he's said to have a cause of action. So when we could talk of crimes, in criminal law, we talk of crimes. In civil law, we talk of causes of action. So that's what we talk about in civil law. And that is the end of classification. There's a lot still for us to learn, especially on the civil and criminal procedure. I'm going to give you those assignments as group assignments. So the group which I'm going to give the team assignments. Have you constituted yourself into teams, please? Do we have teams?
I don't think we have.
Okay, please constitute yourself into teams so that I can give you assignments to work on. That will be your cards. They can be your only cards. If time allows, you can also do a sit-in card. But it is important you start working on your assignment as soon as today. So put yourself into groups. The class representatives, class representatives, take charge and organize your members into groups of 10, 10, 10, 10, 10, 10. In the morning class, what I saw them do is to create a document that someone can edit so that people go there and add themselves into groups. So you may mimic the same place, and it's upon you to find out about them. To organize yourself and give me the groups. But I'll give you the assignments as soon as you give me the groups, which is not later than next week, please. So we have talked. That's one of the assignments I'll be giving you is on those civil and criminal procedure. And before we discuss the rule of law, there's always a fact of history that is disturbing to me, and I want to discuss it with you as my students, because I usually receive news notification on my phone. And currently, I've received a notification. Sorry, that's what is sort of distracting me. And the notification is a science alert. Archaeologists just unveiled a fully intact mummy that has been sealed for 2,500 years. Archaeologists in Egypt said Saturday they have found 59, not even one or two, 59 well preserved and sealed wooden coffins of a recent pigs that were buried more than 2,500 years ago. Opening one of the ornately decorated sarcophagi before assembled media, the team revealed mummified remains in burial cloth that bore hieroglyphic inscriptions in bright colors. The dramatic find was unearthed south of Cairo in the sprawling burial ground of Saqqara, the necropolis of the ancient Egyptian capital of Memphis. We are very happy with the find. Since the find of the first 13 coffins was almost 3 weeks ago, more than in Shaft, so they have found a lot of mummies. They are wooden coffins, so Yeah. The question has been Egypt. Modern day Egypt is largely occupied by Arabs. We just classify them as Arabs. But remember, even Arabs have their own. They have their own sects, like the way people call us Africans. But within Africa, we have thousands of tribes who have different cultural beliefs and other things. So that's what something I've come to learn, that you don't just call someone Arab. These Arabs, they also have their sects within themselves. They're those ones who feel they're those ones who align themselves with Saudi Arabia. So they call themselves the Irans. You know, the way Iran is always, Iran and Saudi Arabia don't get along because they are, and then when you go to Turkey, they're the other group that is always fighting. So it's Sikhs, and they have different classifications. Yeah, maybe someone is helping me clarify this point. Sunni and Shia. Thank you. So they have that, and they fight a lot because of these differences between the Sunni and the Shia. But in ancient Egypt, during that time when Moses was in Egypt, was Egypt occupied by Arabians or was it occupied by Africans? There was one day we had this very, and we want to believe that Egypt was always occupied by Africans, but Arabs deny us that the chance to claim that. They say that they are the original occupants of Egypt.
Africans.
So, yes, even me as an African, I always just say, of course, it was Africans who were there. It was pharaohs were Africans, and everyone else were Africans, because these regions have had early influences by the. These regions have had early influences by Arabs. You see, the influence of Arabs is so strong that the whole of Northern Africa, Morocco, Tunisia, is occupied, Libya. Those are largely Arabian countries. In fact, people refer to us as sub-Saharan Africa. You know, after you've crossed the Sahara Desert, and then that's where you find the real Africans. A place like Egypt, look at Sudan. Sudan is largely an Arabia, an Islamic, and they teach by Arabia. And I don't know why people don't criticize religion. You see, the way religion spreads, it depends on that influence that someone was exposed to. So you are there, very fervent about your religion, but you don't really understand the history of your religion and how a people of a certain society became followers of that particular religion. And you can see the spread of Islam in the coastal lines, even coming to Tanzania, Zanzibar, the Omans that came here to settle early. So it has always been a very strong point of argument. There's also say that it was not Africans. There's also said it was Arabs. So I'm hoping that now that they have unraveled these mummies, they can tell us the Nini, whether they were of Afro descent or of Arabic descent. Oh, Kaya, Ayan, I want to hear from you. Please correct me, educate me, please, Ayan. Ayan, unmute myself and tell me why they're always fighting, if not for religious grounds. What makes them fight? Ayan, Ayan, where are you? I want you to talk a bit, please. We move forward with our class.
Okay. For me, I feel like for me, I'm Muslim, and I know they don't fight because of religion. As per my opinion, I don't think they do fight because of religion, because even when you look at Turkey, Turkey is fully Shia. Okay, it's not fully Shia, but a big part of it is Shia, and they coexist
And now
very
that you're on
peacefully.
Turkey, Ayan, this part of Turkey, the ones that are always been fighting, not the Yazidis, what do they call them? The ones that don't even want to be part of Turkey. There's that part of Turkey.
I
These
don't
people
think
that
I
are
know
always
them.
attacking. Just continue. Continue.
Yeah, so Shias and Sunnis have always coexisted peacefully. Maybe if you look at other factors, like um, control over the Middle East, because of course they're usually grouped into one group, and they usually they're usually in cliques. So each clique want to be identified as the one controlling the region and all that. That's why there's usually some disagreements between some countries. But it's as per my opinion, it's always never about religious factors. It's always about land, control, power, or all that.
Oh, okay, sure. Thank you so much, Anne, for that perspective. Very much appreciated. Yeah. Probably people in power. It's always about power, but really not really. I was not really. I was just saying, why do they fight yet? They share the same religion. They're not as disprinted as Christians are. Are prisoners protected by law, considering the numerous count of sexual offences in prisons? Austin, not a difficult question you've asked. Yes, prisoners are human beings and they're protected by law. It's just that when you go to prison is a world on its own, Austin. It is a world on its own. Being incarcerated is one of the worst things that can happen to any human being, especially if you're a man. Thank God I'm a woman. It is a tough life for prisoners. They face a lot of human rights. They're denied their human rights. In fact, they're even denied their right to liberty. But even within the precincts of prison, they're exposed to other dangers, and the government does not protect them enough. So you have seen those movies about the prisons in Mexico. I don't know if they're that bad, where they're always exaggerated. So there's need for a reform. There are many NGOs who try to fight for prisoners to make sure they also enjoy the protection of the law. There's a lot that still needs to be done. There's been a lot of reform in Kenya as far as the status of prisoners are concerned. Their uniforms have been changed. TVs were bought by Kalonzo Kenyatta for a few prisons here and there, mattresses. But there's still a lot of, in fact, there's no human dignity in some of our prisons. Even you argue against the human dignity in a prison. So it's a big problem, Austin. We are not where we are supposed to be. We are not where we are supposed to be, but there's a lot to be done. And that's why if you're a good, faithful Christian or you're a good, faithful Muslim, you should be visiting people in prison and giving them, visiting someone in prison is very important. Prison is not a good place to be. In world civilization, there were Egyptians, they had a whole religion and culture different from the Christians and Arabs. But the question is, we're not denying that they didn't have a different culture and religion. We're just saying, what was the color of their skin? Mtuma Timothy, can you tell us what the color of their skin was? Were they light-skinned Arabs, or were they black-skinned Afro-Asians? Not know if such a word exists. Swali sasa, where we have been arguing about the color of their skin. It's a very difficult question to answer. Hopefully one day I'll visit Egypt and see for myself. Although now Egypt already is also, there's a lot of protest against Sisi, and I don't know how Egypt will be. There's a lot of unrest there too. Rule of law. So let's come back to the rule of law. Sorry about that historical. I don't know if it's relevant. Our law embody the basic moral values of our society. They impose limits on the conduct of individuals in order to promote the greater good and to make our communities safe places to live. Our laws embody the basic moral values of our society. So they impose limits to the conduct of individuals in order to promote the greater good and to have our communities safe places to live. It is against the law to steal, to injure another person, to drive recklessly, to pollute the environment, etc., etc., etc. So what I'm trying to say in this slide is laws are good. Our laws are for our own benefit. Most of them, not all of them. There are certain laws that are very regressive and they take advantage of common mwananchi. But on the larger part, laws prevent us, they protect us. They're supposed to protect us from criminal conduct. They're supposed to create an orderly society. And then they're supposed to even protect those who are weak from those who are strong, and to control government power, to prevent absolutism. So they're very good functions and that laws play in our society. So because of this good that the law plays, it is very important that everyone respects the law. The concept of the rule of law is about respect for the law. So we are said to be ruled by law, not by those who enforce or wield government. Sorry. That is why, because of the function that the law plays in a society, that is why there should be respect for the law. So we are said to be ruled by law, but not those who enforce the law or wield government power. So the rule of law dictates that no one should be above the law. Everyone, no matter how wealthy, how powerful they are, they must obey the law. If you don't obey the law, you face the consequences of it. And the rule of law is a concept that we have struggled with in our Kenyan society, where there is a lot of anarchy. In Kenya, the law, it's mwenye nguvu mpishe. Okay? The law hardly plays the role it's supposed to play of protecting. It is sort of like mwenye nguvu mpishe. So that's a huge that has been a huge problem for us. About these issues of mwenye nguvu mpisho. So we are said to be ruled by law, not by those who enforce the law or wield government power. No one in Kenya is above the law. Everyone, no matter how wealthy, should abide by the law. Look at our parliament. Our illegal parliament, our unconstitutional parliament. We have a constitution in place, yet parliament has failed to abide by the constitution. So that's a very huge problem we have in Kenya. And because of that failure, it is now upon the president to dissolve it. So the concept of the rule of law is a framework developed by DICE on the basis of English legal system. It is also described as a due process of law. So as a concept, whenever you're learning about a new concept, I'm teaching you about a concept, a very important concept of law. This concept is called the rule of law. And first and foremost, I started off by telling you why the law is important. And the reason why I was telling you the law is important, to create a rationale for you to be very much persuaded that it is a very important thing for everyone to abide by the law. The rule of law is about respecting the legal rules of a country. And anyone who does not respect the legal rules of a country must face the consequences. So that is the rule of law. Why is it important for us to respect the law? Because the law is there to give us good things. It protects us. It does all these things to us, although we know we have bad laws as well. So who developed this concept? Okay? Who came up with this concept of the rule of law? Every idea has a genesis to it, yeah? Even the idea of studying, the idea of Zoom, you can very much investigate the history of Zoom as a platform and see who is the founder, how did they start, how did they think of forming a meeting room like this, what codes do they use? You're the technocrats, yeah? So every idea that we see is functional and you're benefiting from it always originated from somewhere or from someone is associated with that idea. So when it comes to the rule of law, there are many people associated with this concept, the rule of law, but key among them is someone known as A.V. Dicey, that the concept of the rule of law is a framework developed by Dicey on the basis of English legal system. It is also described as a due process. Rule of law implies that every citizen is subject to the law, including the lawmakers themselves. Every citizen is subject to the law, including the lawmakers themselves. And so these are the three things that must be there for us to say a country follows the rule of law. Include the following: one, absolute supremacy or predominance of regular law. This means that all acts of the state are governed by law. So the law should be supreme, and then even the state should not be above the law. The government should not act out with the law. It should act within the law. Does our government act within the law in your view? Students,
No, it
does
doesn't.
our government act? Yes, please.
I don't think it does.
Give us an example where the government has violated the law.
Just to go back on the unconstitutional parliament we have, I think the same can be seen in our executive, where there's no obedience to the two-thirds rule.
So the obedience to the two-third rule. Give us another example of the government failing to obey the law. Miguna. The court issued orders that Miguna was to be allowed within the country. The court issues orders that Miguna was to be allowed within the country. Did that happen? Has the government ever issued Miguna with a passport? Yeah? So that's another example of the government breaking the law. When our president appointed chief administrative officers, these are not offices created by government. They're not offices created by government. So chief administrative officers are not there. That was acting against the law. When so many things, court orders not being obeyed, the president refusing to swear in judges, the cabinet secretaries. Cabinet secretaries not obeying the law, parliamentarians not obeying the law, governors breaking the law. Oh, niko class. Siwache tu hivi ama atatoroka. But niko class. Wacha tu hivi ndio uende. Eka kwa gas. Hiyo makaa ndogo niweke njugu kidogo please. Half of hiyo njugu. Njugu eka tu hapo. Njugu unajua itachomeka kama makane kidogo. Oh, sorry, my ear. You are listening to me. Oh, my dear. So what do I want to do? I know. I feel like ending the class and running away. I should report my privacy. This thing of teaching online. The rule of law implies that every citizen. Oh yeah. I was telling you about the examples of our government not obeying the rule of law, not obeying court orders. When a government disobeys court orders, it does not obey the law as well. So we have had very classical examples. We have seen Sonko in action, running away until helicopters are following him. After these helicopters have followed him, what happened to him, by the way? The case, has it continued on? So there's a lot of playing around with the law. Maybe he was being arrested so that Nairobi Metropolitan can be created. I hear those were the things that were used for negotiation for him to sign off his powers to. So once he did that, the corruption cases, have you heard of them in the media again? It's like the corruption cases disappeared. So that is not abiding by the rule of law. So the government, in case we were abiding by the rule of law, the government is it means all acts of states are to be governed by absolute supremacy or predominance of regular law means that all acts of the state are to be governed by law, equality before the law. This means equal subjection of all persons before the law. It means that no person is exempted from the law. Do you think the law of Kenya treats everyone equally? That's another question for you to ponder about. The law, the constitution should not be a source of rights, but it should express the will of the majority. So when you're making the law should not just be made from parliament without consulting the public, and then you want to enforce it. It becomes very hard to enforce such a law. People should participate in the lawmaking. The law should be an embodiment of the will of the majority, how they want to be governed. So that's what the law should be. And when the law reflects the values of a society, then you don't have to compliance become very easy. Oh, okay. No, you can't sign in now until at the tail end of the class, but at least you've told me your internet is having problems. Okay. What time is it anyway? Let me check my watch. Oh, 6. We still have a bit of time. That's a lot of time. No signing in now, please. The class is not ending anytime soon. Factors undermining the rule of law. The factors undermining the rule of law, we have already looked at the rule of law. We have said as a concept, it was developed by, it is associated by one of the past people it's associated with is Evie Dicey. And Evie Dicey, when he explained this concept, he came up with the 3 conceptions of the rule of law. The first one is absolute supremacy of the law, or predominance of regular law, so that all the actions of government must be done within the law. The second one is equality before the law, that everyone must be treated equal before the law. The law should not distinguish between the rich and the poor. We know the law does not do this most of the time. And then finally, we are saying the constitution of the law should not be a source of rights. Not that, but it should not be just a source of right, but it should be an embodiment of the will of the people. So factors that undermine the rule of law include the following. An excessively powerful executive. You see, the president controls the parliament. So the parliament, once the executive controls the parliament becomes a bulldog without tooth. So it just barks and it cannot bite. Because the majority in that house are from the Jubilee Party. So the president already has a majority in the house, and hence he can manipulate the house. No, and the house cannot have oversight roles. So there's a conflict of roles there. Excessively powerful executive is harmful to any society. So the executive must always be tamed, and its powers must be checked through various oversight mechanisms. But that does not seem to work in Kenya. And an independent judiciary, that's another fact undermining the law. The judiciary is one of the most important arms of government in a country's legal system. So they're supposed to ensure that all the work of the government is done very well, and the work of the government is done, the laws are complied with. It must interpret and enforce the laws up to the level of compliance. But when the judiciary is not independent, then we have another problem that we have to go through. Corruption, selective prosecution, civil unrest, ignorance of the law. So all these are factors that undermine the rule of law, and you know how they undermine the rule of law. So that marks the end of our chapter number 1. So I want to introduce sources of law to you, because we not have a chance to do sources. So that next time when we meet, we can start on regulation of IT. So very quickly, let me introduce sources. Before I introduce sources, of course, I have to play for you a video. Did you see what happened in this weekend? Oh, it was devastating. Eliud Kipchoge lost the London Marathon. Anyone saw that? Mm. But that is life, eh? You can't win them all. And it does not take away his. No, don't say no. Tweetoik, please. Eliud Kipchoge is still very rich. It's just that he lost. That is life. You cannot always win all the marathons. So he lost the London Marathon. London Marathon. Eliud Kipchoge. I think after the honors challenge, Eliud Kipchoge should just make appearances in Nini. Oh, That was him winning the 2019 London Marathon at 2 hours, 2 minutes and 37 seconds, the second fastest marathon of all time, behind the lines. So, but this is his defeat. That is the thing. Life is always also about defeats too. It is not a sin to be defeated. There is that video. So the greatest marathoner in history lost for the first time in 7 years at Sunday's chilly, rainy London Marathon, ending a streak of 10 straight wins over 26.2 kilometers. 10 straight wins. So, Kipchoge dropped behind a leading group of 6 men in the 27th mile and never regained contact, placing eighth in 2 hours, 6 minutes, 49. The Kenyan cited a blockage in his right ear over the last 10 miles and leg and hip cramping, but didn't blame the 50-degree weather. At the last 5 kilometers, I discovered that something is wrong, said Kipchoge. A 35-year-old shivered through a thick jacket in a post-race interview. My legs were not moving. My ear is totally blocked. I tried to keep on with the pace and try to finish. So that is our Kipchoge for us. The best thing is that he still finished the race.
It's a chance now to re-rack the highlights and look at the men's elite race where all eyes were on the world record holder, Eliud Kipchoge. And as this race unfolded and the group stayed very big, the storyline just kind of wrote itself. It was going to be a tough day for him.
There were so many men in that pack that had such great credentials. Kipchoge let the pace get very slow, but we kept wondering when this world record holder would throw in that style, that mile that we have seen him throw in the past, some 4:30 miles, 4:35 miles. It just wasn't his day today. As the miles went on, we never saw that spark in his step, and other people took over, swallowed him up, and he fell off. Today was a rare day where he just wasn't feeling himself, obviously, because as you can see, here is a gap. And as soon as these guys realized that Kipchoge was no longer there, they started pressing the pace. He was the one where as soon as he was gone, the race got going.
Yeah, those guys in front of him probably motivated by the fact that they were creating space. And then it set itself up for an old-fashioned sprint to the finish.
With one lap to go, it was finally down to 4 with only 3 spots on the podium. Lemma, Chipchumba, Garamu, Katada. Garamu off the back, down to 3. But who was going to be this year's champion? Only this sprint would tell us.
And
Chipchumba for the lead. Katada back. There are so many place changes over this last 400 meters, but what it came down to was who wanted it more. You could see Katada digging there. Kipchumba's doing everything he can, but he just can't keep up with the runner-up from 2 years ago. Katada, 2:05:41. Kipchumba, 2:05:42. And Lemma, 2:05:45. This was a close finish. Kipchoge rounding it out in 2 hours, 6 minutes, and 48 seconds. Far off of her.
All right, so that was Kipchoge, and that was the London Marathon yesterday. It's okay. It's not a must to win. He has had so many wins. Personally, I didn't know he has been a winner the last 10 times. 10 straight wins over 26.2 miles. Kipchoge has had so many wins, and I think it's not the end of Kipchoge. It's never the end of a great athlete like Eliud Kipchoge. It's just the way life sometimes is. We don't win all the races. But I trust we're going to see his comeback and another win for Kipchoge. Yay! Then, having shown you that video of Kipchoge and what happened in the London Marathon, everyone to never take pictures of the blow. So let me teach you sources of law, and we can start from there. But before we go to sources, I want us to try and do some definitions of information technology and business law. So, what is information technology and business law? So, information technology and business law is not really a special. I can't tell you information technology and business law is a specialization, a specialized area of law, so that they are just specific things you're going to learn. Information technology and business law, computing and business law are just they are. I'm trying to look for the right word here. Mm, a cocktail. You can define it as a cocktail of different areas of law. Yeah. So you take contract law, a bit of tort law, every part of the law is relevant to this concept of information technology. And that's what I want you to learn. Though we might have most of the laws that we learn as regulating technology is just communication laws because information technology has changed how we communicate. Then there have been attempts at creating crime as well. So I think this we can Maxwell website can do as the justice. We know that information technology law is fast paced, which is why we work with top names in the industry, provide you with a selection of books. Streets and Maxwell is a publisher in UK. Loose leaf encyclopedias and journals together, they bring you up to date with the latest legislation, cases, expert opinions from the UK and abroad. Our information technology law titles cover many areas, including data, IT, telecommunication, audiovisual services on the internet. Also covered are subjects such as IT contracts, data protection, freedom of information, electronic identities, electronic signatures, EU regulations, internet law and regulations, and software license. So those are, you can see it's what is what I'm looking for, a conglomerate, let's say like that, a combination of several areas of the law that you're supposed to learn as information technology. So some of the best books there are from Switzerland Maxwell. And read those ones there. When it comes to electronic signatures and laws, if you look at a book on electronic signatures and laws, do you know that is 40,000 pounds. So it's all about some of them are most of those books that we have looked at, and just to help you understand what we mean by information technology law, you find that you're only learning about, even if it is electronic signatures and identities, how these identities are protected, why they should be accepted as matters of contract. Because even now, most of the approvals that people have to do, they have to come up with electronic signatures, and that should suffice as an approval. If you're to negotiate a contract, you may not find a physical signature on your contract, but you may find an electronic signature on that contract. So those are the kind of updates that we are having as far as contracts are concerned, where people are using even electronic signatures, and the need for law to give those electronic signature a legal backing to say that these electronic signatures are good enough. If someone signed using them, then they should not be taken not to have signed the document properly or not to have given a valid approval. So those are the things going on right there. But likely information technology is just so many areas put, so many relevant areas of law put together. And from I cannot pretend to be one of the best experts, but one of the highlights that we need to also have. Okay. I've seen some of you have decided to take attendance. If you take attendance and leave the class before I allow you, I will mark you absent. All of you who left the class last week when I was showing one of my favorite philosophers, and some of you just walked away on me. Really. You walked away because time had. What were you supposed to do? Unless you have a young child who you're taking care of at home, I will mark you absent. I took an attendance after everyone left. So please just put your attendance. That's fine. I see you have started. Go ahead. But if you leave the class after this, I will mark you absent times two with an emphasis of your absence. I always like the concept. So this is a loaded question. Perform a background report and email the administrator access, comply with local, national, and international law regulations. Companies outside the EU should comply. They don't destroy data, have policies and procedures in place for data handling, treat data with personal identifying information. So, information and technology law is a collection of different areas of law that are relevant. They are relevant and regulate and touch on transmission of information through internet, transmission of information through mass media, transmission of information through radio and mm, broadcast. It is quite broad and it is also it touches on electronic commerce and the processes of contract making, and even it has aspects of malpractice when it comes to failure to comply with the regulations that are in place. In Kenya, as I mentioned in the beginning of class, we don't have too many laws that regulate information technology. They come in the shape of a few statutes. For starters, we have the Kenya Communication Act that has been there for a while now. And then secondly, we have the Cyber Crimes and Economic Crimes Act of 2018. Thirdly, we have the Cyber Crimes Act, we have the Access to Information Act, then the Data Protection Act that was passed recently. So those are some of the laws that we're going to start off with a very learn about sources of business what IT law is about. But in addition, we're going to look at the classical areas that most students look at when they do business law, which includes the law of contracts, the law of torts. On your case, we're going to also bring issues of intellectual property rights that we're going to discuss in detail. I have come across so many good blogs that discuss whether information technology should be regulated, if at all. And there have been a lot of debates revolving around that and whether information technology as a subject should be regulated. Moving forward, let me open the new slide. So most of the time you'll find that when people teach information technology, cyber law, most of the things they do is simply to talk about crimes that have been created as well to protect users in the internet. So, for example, this is Oxford Press, of course, very rich and authoritative. If you look at the chapters in this book, I can just give you an impression of what it's all about. Privacy, anonymity, and data protection, computer-related crimes that I have mentioned, intellectual property issues that we're going to look at, and e-commerce. So this is what the book entails, 24 chapters. When it comes to privacy, anonymity, and data protection, the data protection principles, individual rights and remedies, what happened when someone infringes on those data protection laws, national and international responses to computer-related crime, substantive criminal law provisions, the emergence and forms of intellectual property law, key elements of the patent system. So, yeah, those are the things that we will be covering, some of those topics in the Kenyan context, and that is information technology law to you. Now to sources of law. So I think I will end the class here. I've had a long day. Maybe we can pick up on sources now next week. Any questions, please? I'm coming back. Questions? So not leaving the class, please. I am not done with the class. I have not closed the class. I'm coming back to discuss the group assignment. Give me 1 minute. Sorry. So back to what's up? Uh, Groups, I need for you to form yourself into groups of 10, please. I want the classes to tell me when I can have this group list names because I have the assignment ready and I need to give it to you. When can we have this group lists ready, please? Yeah, when can we have this list ready for the groups?
For my group, I've already sent the document, the spreadsheet for them to fill in. As soon as they do, maybe like tomorrow, send it to you.
Okay, thank you so much. And the rest, please?
Can you hear me?
Yes.
Like Wednesday, maybe.
Okay, Wednesday, Sawa. Please make sure I have all that so that we can work on them. Thank you so much. On that note, that will be the end of our class for today. I'm sorry for the interruptions we had in the beginning of the class. I had a number of issues I was trying to sort out, a bit of technical features, but I thank you for your patience. I look forward to seeing you next Monday. I was wondering, is it possible to start this class earlier than 2:15? Class reps. Maybe you're tired, yeah? Because I see you already have a multimedia class. But that multimedia class, is it a class where you really learn, or is it a practical class? Is it possible to start at 1:15 perhaps?
I don't think so because we're usually just from the other class. It's usually very
Okay.
engaging.
Okay, sawa. All right, that's fine. Thank you, everyone. See you to next week, God willing. Bye.